3, 2, 1, start. The amicus curiae K. Parmeshwar placed the recommendations of the Commission and its reasoning before this court. Detailed notes of submissions have been filed by the amicus curiae, tabulating the recommendations and supplementing the same with additional reasoning. He also detailed the objections put forward by the states and the Union and rebutted them with clarity. The amicus curiae also laid stress on the principles on which the recommendations of the Commission draw their strength. He broadly suggested 5 principles for the consideration of the court. Firstly, he submitted that the independence of the district judiciary is part of the basic structure of the Constitution. He stated that the judgments of the court thus far have recognized the principle of independence of judiciary only in the context of the High Courts and the Supreme Court, and submitted that this principle ought to equally apply to the district judiciary. He then submitted that the principle of independence of the judiciary is an integral part of Part 3 of the Constitution, as it ensures a guarantee to a fair trial. He argued that therefore the independence of the judiciary must be seen as a guarantee under Article 21 of the Constitution. The third principle in his submission was that the doctrine of inherent powers, as noticed by this court in Brij Mohan Lal versus Union of India 2012 6 SCC 502, and suggested by the report of the Task Force on Judicial Impact Assessment (chaired by Justice M. Jagannath Rao), would require the judiciary to compel payment of reasonable sums of money to carry out its constitutionally mandated responsibilities. To this end, he also relied on Article 50 of the Constitution, which mandates that the state shall take steps to separate the judiciary from the executive in the public services of the state. He then submitted, relying on the order dated 5/4/2023 passed by this court in the review proceedings, that there is an equivalence of core judicial function between judicial officers in the district judiciary and the judges of the High Court. Therefore, he submitted that the increase in pay of the High Court judges must equally reflect in the increases of pay of judicial officers of the district judiciary. Lastly, he submitted that in a unified judicial system, the service conditions, designations, etc. must be uniform across the country. He relied on the judgment of this court in All India Judges Association versus Union of India 1993 4 SCC 288, as well as the reports of the FNJPC and SNJPC, to contained that the uniformity must be maintained across the country in terms of pay and designation of the district judiciary. The petitioners, that is the All India Judges Association, were represented by Gaurav Banerjee, senior advocate. He supported the report of the SNJPC and supported the arguments made by the amicus curiae. He also brought to the attention of this court a recent decision in Director KPTCL versus CP 2023 SCC Online SC 401 to defend the recommendation of the Commission on the accrual of last increment for the purposes of pension. He also sought to support the recommendation of the Commission on additional quantum of pension to be given from the age of 75 years by contending that the same is not only reasonable but is also already given by a number of states from an even younger age. In this regard, he also submitted that the age of retirement of district judges is lower than that of High Court and Supreme Court judges, and therefore they must be entitled to retirement benefits at a younger age. Stop.